Good evening, this is Rahul Reddy. We are here live from Houston, Texas. Every week, REDDY NEUMANN PC does bring business immigration updates. For those people who are new to this one, please subscribe to our in-law group, and please come every week. We do give updates for those people who, for the business immigration. Emily, what do we have today?
All right, well, first I want to say happy Thanksgiving a little bit early, but that is coming up this week, so hopefully you can enjoy some time and enjoy the wonderful Thanksgiving tradition that is the United States of America. We're going to be talking about recent lawsuit that we have filed against USCIS regarding an H-1B denial and what kind of results we saw from that. We wanted to update you on the latest regulations that we're expecting to see from the Trump administration over the next year, as well as some changes or updates on what's going on with the visa bulletin, specifically for the rest of world category for EB2 and EB3. We might see some changes soon on that. And the latest updates on the STEM OPT litigation that is going on in the district court right now.
Emily, in the statistics of the USCIS right now, 30% of the H-1Bs are getting denied. And most of them are getting denied for the specialty occupation. What the USCIS is telling is that you have to meet the 4 requirements of the specialty occupation. We all know that in the law, it only requires only 1 out of the 4 requirements. So explain about this lawsuit. What have you guys done on this one? So you sued the USCIS on the grounds that they improperly denied, and what exactly, how does the process, how long it took for you guys to get a result?
Yeah, so this was a case that had been filed in April of 2019 in the lottery. It was selected in the CAP, received a request for evidence, and then received a denial in August of this year. And so rather than filing an appeal or a motion to reopen with USCIS or the Administrative Appeals Office, we went straight to federal court and basically sued under the Administrative Procedures Act, which says that any government agency must act, it cannot act in an arbitrary and capricious manner, meaning that it's the decisions have to be logical, they have to make sense, they can't, you know, if you're given 2 cases with very similar facts, you should end up with similar results. And we're finding again and again that cases with similar facts, one gets approved and one gets denied. That's the clear definition of arbitrary. And so that was our argument. And typically when we file a lawsuit, the government has 60 days in order to respond to the court with what actions they intend to take, whether they're going to ask that the case be dismissed because it was not a strong case on our side, or if they're going to fight it, or what we saw in this case was we never even made it to the 60 days. The USCIS turned around and reopened the case, and then we found out this week that it has since been approved. There was another request for evidence also on specialty occupation, so we were given the opportunity to submit additional documents, not to the court, but to USCIS, and then we found that USCIS actually approved the case, so now we can dismiss our lawsuit.
So you got the H-1 approval, but technically immigration won in the court.
Right, yeah.
So the way the litigation works is that there are 4-prong rules for the specialty occupation. So the 4-prong rule is that the bachelorate or higher degree is normal and minimum for the position, or the degree requirement is common to the industry, or the employer normally requires degree as a minimum requirement, or the specific nature of the position requires degree as a minimum requirement. These are all according to the regulations, and I put it for you. This is the regulation, guys, for you guys to look into it. And it says very clearly to meet the requirements of the specialty occupation, it is not and, it is or for each of those topics. You can look into very clearly, and you can look into one of the articles that we have published into. However, the way the USCIS interprets is that the employer needs to meet all 4 requirements, which is completely contrary to the regulations. So when we go to the court, I mean, practically by the time we go to the judge, and if judge listens to our argument, we have a good possibility of getting the approval. Now, however, the immigration don't want to lose in front of the court. So what they do is that, as what they did with Emily's case, is that they reopened that case and they just reissued the RFE, and then the employer responded to the RFE and they approved it. I mean, that is the typical thing that goes on when we go to the court. Does all the cases get approval in the same fashion? Most probably yes. Not all, but most of them will get approved. They would reopen it and they would approve it. Under this administration right now, the denials went up very high. Was there any change in the rules or regulations? No, none. How come the denials are going on? As Emily pointed out, if you have given the same circumstances under two different cases, you must see a similar result. Are we seeing the similar results in similar cases? No, we are not. Now, what's the difference between 2016 to 2019? Why are we getting more denials? Is there any change in the regulations or rules? None. So these are all the things that you can present it in front of the court, given an opportunity if they don't approve your case. Once they approve the case, it becomes moot. We are forced to withdraw our complaint, and that's what we did in this complaint, is that we're going to withdraw the case because there's no reason for us to fight because our H-1B is approved. But I would suggest people that if you get your H-1B denied for either specialty occupation or employer-employee relationship, you should try to take it to the federal court. It's going to be a little bit expensive, there's no doubt about it, but this is the only way right now if you want to get the approval. You go through the process of filing a motion to reconsider, or you file an appeal. You're still going to the same agency, which is not, it's not a court when you appeal it. The only thing that you go to the independent judge is by going to the federal court, not by appealing the decision with the USCIS. And a higher level officer will look into it. And by the time it goes to the administrative appeals unit, you get a decision, it's going to be a couple of years, and you may not have a job by that time. So it becomes moot at that point of time for you to fight the case. I would strongly urge that, guys, if you get the denial, try to get evaluated by the litigation lawyers. That's much better rather than filing a motion to reconsider, motion to or appeal. Emily, on the Trump administration agenda that we have spoken that out of the 4 requirements, only 1 requirement is to be met under the current regulations. And now you said that the Trump administration has an agenda. Is this regulation is going to be the same, or is it going to be different?
Well, that is exactly one of the regulations that the Trump administration is looking at changing, and that is the definition of specialty occupation. Now, they can't change the basic definition of specialty occupation because that is set by Congress in the actual Immigration and Nationality Act. So what they're doing is wanting to revise how they're implementing that definition, adding some additional guidance. Do we know what that is going to be? No, and this might not come out for another year. So possibly next fall, we could finally see a proposed regulation that seeks to change or modify how we look at specialty occupation. I can only guess that it's going to be more difficult to prove specialty occupation under this new proposal rather than easier. Also, they're looking at changing the employer-employee relationship, so this would definitely impact third-party placement type situations. So that proposal, again, might be coming out. Actually, I take that back. I said next fall, but we are supposed to be seeing it this fall. Now, when it came out in the agenda before in the spring, they said we should see a proposed regulation in October 2019. Obviously, we didn't see that, but it does look like they're wanting to get something proposed by the end of this year. Keep in mind that doesn't change anything immediately. It's just a proposal. Everything will stay the same while that's going through the process. And this has already been delayed at least once or twice, so it could be delayed even further. We've got new people in charge at USCIS every other day, it seems like. So these things might take time. In addition to changing the definition of specialty occupation, it looks like the L1 is going to be the new target. They want to modify how they look at what is specialized knowledge specifically for L1B. I can only imagine they're going to make that more difficult. We still know that they plan on eliminating the H4 EAD through regulation, even though we have the court case going on as well. So that we might see a proposal March 2020 at the earliest. Increased filing fees, more oversight of students. So they're going to be looking at the optional practical training, possibly changing some regulations there. Unlawful presence, possibly changing that. We already know they tried to change unlawful presence by memo last August. Now it looks like they might be going through the regulatory process to get that done. And they're even considering eliminating the idea of duration of status, or that D/S that students get when you enter the country. So as long as you are continuing a program, have a valid I-20, you are maintaining your F1 status, rather than giving each student a specific end date like most other types of visas. So now they might want to consider giving an actual end date.
So every time they go to the OPT, they have to still extend the I-539 and the whole 9-yard process, fingerprinting, that's biometrics and all those things. So overall, it looks like that the Trump agenda is going to be very restrictive. I think so the only way to counter is to file a class action on these things, Emily. Because when we have no say in the administration and the Congress or the Parliament is absolutely not acting on it, the only way to do it is by going to the class litigation. So we at Reddy Neumann PC are contemplating to prepare ourselves and also you to these new regulations, because without the Trump administration passing any regulations other than the lottery system update that they have done, which is a very good thing that they did on the lottery system, without them doing anything on the regulation, the denials went up by about 400 to 500 times that it went up. So with the regulations, we do expect that things are going to be more nasty. At least without the regulations, we have a relief in the court. With the regulations, though, we have to fight the regulations. We can't go based on the Administrative Practices Act. We have to fight the regulations. So we are contemplating to consider into class action litigation. That's going to be very expensive, especially if the H4 EAD has been taken. Emily at her blog Immigration Goal has already collected a lot of survey. We are contemplating to do the class action litigation on these things. Now, the basis for this is that the administration is trying to undermine the legislative process. That's one of the things. And also the data that they're using is more discriminatory basis. That's the reason why we want to consider the class action litigation. It's going to be very expensive, but before the regulations come out, we want to prepare ourselves. We want to issue the freedom of information to the USCIS, what statistics they have to eliminate the H4 EAD, what statistics they have with regards to why do they want to change the regulations on the H1B, why do they want to change the regulations on the L1? Is that the Congress intent, or is it the administration have their own intent? If there is intent, is that based on the race? Is that based on the nation where the persons are being born? So all these things we want to issue freedom of information. Before the regulation, they're going to propose the regulations, because when we are going to sue them, we want to have all this information. And the reason why we want to file all this freedom of information is we are anticipating all these things to come in this administration. So get all the information, make ourselves ready to sue the government when they are going to issue the regulations. Please keep watching the YouTube and Facebook, and also Immigration Girl at our in-law group. We will update you more on what we want to propose, though. Emily, on the EB2 and EB3, you said there's going to be a backlog on it. What backlog? It's already 2009. What more backlog are you expecting?
Well, as of right now, EB2 and EB3 for the rest of the world has been current since October.
Oh, you mean to say for the rest of the
yes.
world? The rest of the world.
And
okay.
So, in this visa bulletin that's coming up in December, at the very bottom of it, there's kind of a hint that EB2 and EB3 for the rest of the world may retrogress as early as January, which is quite early. Usually that doesn't happen until the summer. So they've seen an incredibly high demand of EB2 and EB3 I-485 filings with USCIS after the October visa bulletin came out. So if you are in EB2 or EB3, rest of world category, to where right now your date's current and it's current in December, really important to file your 485 before the end of December, because it's very possible you might lose the opportunity in January. So just be aware of that.
So this you're speaking only for the rest of the world
right.
people, not much for the Indian nationals and Chinese nationals.
Yeah.
They're already in the water, so they can't be any harmful for them.
Yeah, and the only update on EB1, we know EB1 India, China, not really moving. EB1 rest of world, the filing dates chart is actually current for December. And USCIS finally announced that we can use the filing dates chart for the month of December. So if you're EB1, rest of world, you should definitely be filing your 485 in the month of December while you can.
Any update on the STEM extension litigation? What is the STEM extension litigation? Can you explain the process of what is going on in the court?
Yeah, so this has been going on for years. Litigation is actually what caused us to get the 24-month STEM extension. There was a group of tech workers that brought a lawsuit against Department of Homeland Security for the old 17-month STEM extension rule. The court actually vacated that rule or wiped it out and caused the Department of Homeland Security under the Obama administration to issue a new STEM extension rule that extended it further for 24 months. That's where we got our training plan requirement and these new commensurate wage requirements. So ever since that new regulation came out, a new lawsuit was filed, again by tech workers, U.S. workers, claiming that the STEM OPT rule itself is not authorized by Congress, that the Trump administration and the Obama administration did not have the authority to grant employment authorization to students after they already graduated. And so that litigation has been going on. It was with the appeals court. Now we're back to the lower court. And just last week or earlier this week, a group of 118 different colleges and universities filed a brief to join in to this lawsuit in an effort to defend the STEM OPT and explain why we need OPT, why it's important, what benefit universities get from it, what benefit employers get from it, and the students themselves. So I think that's an important step, and hopefully will draw the court more towards keeping the STEM OPT.
STEM OPT. Let's go to questions, Emily. Live questions that are there. Indu Kumar from Facebook has this question. Can we file a group litigation for the H1B denial? Most probably the answer would be no, Mr. Indu Kumar. We are grouping on some of the short-term approvals. We are able to group up some of the employer-employee relationship denials, but we are unable to group the specialty occupation denials, though. In general, Mr. Indu Kumar, unlike the H4 EAD, where we group up all the people who have been delayed, we file the litigation, which is going on very smoothly, except about 5 or 6 cases that got stuck. Out of the 500 cases that we filed, all of them are approved in the proper timing. We most probably cannot do the group litigation for the H1B denial. It has to be, most probably has to be an individual basis. However, you can make a consultation with a litigation lawyer. You can contact our office or any immigration litigation people, and they may be able to guide more on that. Do you have any thoughts on the group litigation, Emily?
Not at this point. Yeah, I think that it's tough for H1Bs employees to group together for litigation because each case really has different facts, different documents were submitted, different reasons for denial, so it's hard to group all of that together into one cause of action. We have seen employers where one employer may have had multiple denials, they're able to combine all of that into one lawsuit, so that may be possible. But as far as group litigation for many different types of H-1B denials, I think that'd be tough. Kirti from Facebook wants to know a little bit about the Freedom of Information Act request for an I-140 approval. So we've talked quite a few times here about what you can do if your employer is not willing to share your I-140 approval notice, which you need in order to obtain H4 EAD for a spouse, or you can use it to file a transfer, to get a 3-year extension with the new employer. So you do need that documentation. So you can submit a Freedom of Information Act request or FOIA request. It can actually be done through the USCIS website online, which is quite a bit faster and easier to do. And you will not get the approval notice itself, but you'll get a copy of the I-140 petition that shows it has an approval stamp on it. Kirti wanted to know if there's a way for her employer to find out that she's made this request, and no, there's not. It's just between you and USCIS. It does not come to the attention of the employer at all.
Kani Adi from Facebook has this question. Can we contribute to the the class action suit that we are intent to bring on the H4 EAD removal and other things, yes, we do. We're considering legalities of how we can collect the money and how we are going to form the trust pretty soon on that, and make sure that the money is appropriately accounted, every bit of it, and what are the alternative things if we don't use the whole money, which charity it should go. All those things should be specified very carefully. So we are working on the legality on that to bring the class action suit, especially for H4, not just for H4 EAD removal, but also for the restrictions on the H1, L1, and other aspects of it. On the aspect, I have another question that came from YouTube, Emily. They're saying, in March of 2020, is H4 EAD is going to be still there, or it's not going to be there, Emily?
Yeah, it's definitely going to still be there. So remember, all they're doing is proposing to eliminate the H4 EAD, and they haven't proposed it yet. The earliest we might see that proposal is March 2020. Once it's proposed, it still has to go through a several months long process. They're going to be collecting comments from the public about why we should or shouldn't rescind the H4 EAD. They have to review all of those comments, come up with a final regulation, give that final regulation to the OMB, Office of Management and Budget, for review. Once they approve it, then a final regulation could be published, and then it would take effect in the future. So nothing is going to change in March of 2020. You'll still be able to file and receive the H4 EAD even while the regulatory process goes on.
Nikhil from YouTube has this question. His H1B transfer got denied. He went to his home country, got the H4 stamping done, and now he wants to file a change of status from H4 to H1. Does he need to go for stamping for H1B? The answer is no. If you are here legally on H4, you can transfer from H4 to H1B. Since you're already counted towards the H1B number before, you don't need to be counted again. You can transfer to H1B. You don't need to go for stamping.
So we have a question from Natansh kind of along those lines. We've talked before about once you have an I-140 approved, you can kind of get your H-1B back even in the future, even after you've used up your 6 years. Yes. And he's asking, his firm is saying he's not able to do that. Yeah, so this was clarified in the January 17, 2017 regulation that said there's no kind of time limit on being able to use an approved I-140 to get 3-year extensions beyond the 6-year limit. Right.
There is only two caveats. That the I-140 must have been approved for more than 180 days, and it must not have been withdrawn before January 17th of 2017. Since the regulation went into effect on January of 2017, if it's withdrawn before, yes, you cannot use that. And the other thing is that if the I-140 has been withdrawn before 180 days after it's been approved, you cannot use. But once it crosses 180 days and it crossed January 17th of 2017, practically I say to people is that belongs to you now. It's started to your face. There's nothing you or anybody can do it. To take it off. Even if your ex-employer withdraws it after 180 days and after January 17, 2017, that is yours. We have had situations where people had an I-140 approval in 1999. They left the country. They are living happily in India. Now, all of a sudden, they come here on H-1B. Their I-140 was never been withdrawn. So we were able to recapture that date. There are so many situations where we have done. And you can, even if you have completed the 6 years, if your I-140 is there, it's not been withdrawn, you can always restrict your H-1B. Absolutely no problem with it.
Saptarshi from YouTube wants to know if there's any gap required between PERM approval and I-140 filing. No, there's no specific gap there. You just have to make sure that the I-140 is filed within 180 days of the PERM approval, otherwise the PERM expires. I mean, there's technically a little bit of a gap because once the PERM is approved, the attorney or the employer has to receive the physical labor certification in the mail, so that takes maybe a week or two, and then they have to get the signatures on that original before they can actually file the I-140. But other than that, there's no set time period that you have to wait before you can file the I-140.
Abhishek Gautam from Facebook has this question. Are there rumors on Trump's point-based immigration bill? There are so many other bills that are there. Point-based is one of the proposals that he made. To tell you the truth, the likelihoodness of that to be passed in the next 5 years would be, I want to give percentage, less than 1%.
Yeah, I agree.
With the Congress right now. You know, I've been an immigration lawyer from 1995. So, you know, to pass a bill in the legislation, it's not that easy. Especially in this administration, it's not easy. Clinton administration tried to pass a bill, major immigration bill. He couldn't pass any major immigration bill. Bush administration tried to pass a major immigration bill, couldn't do it. Obama administration tried to do it, couldn't do it. That's 24 years gone, nothing happened. Now we have Trump administration, which it is, you know, the Congress is not in his favor anyway. So it's very unlikely that such a major bill is going to be passed anytime soon. With regards to the chances of Senate 386, it's a small bill, Romy, from YouTube. It's a small bill. It has a chance of approval because it's not a major bill. You guys still need to keep on doing a lot of efforts. Don't just settle down with Senator Durbin. Keep contacting every senator, every congressman that you are located at. Don't give it up on Senate 386. These kind of small bills, we have noticed that they pass miraculously because it's a small bill. It is not increasing the number of green cards. It's not doing anything different. It's just taking the discrimination off. That's all. But when you guys are going to call the senators or the congressmen, don't tell that this bill favors Indians or Chinese. It doesn't. It just makes everybody equal, and that's all we want. So keep trying on that one.
Karthik from YouTube had his case denied recently, and his attorney suggested that it was an arbitrary denial because all of the evidence was submitted properly, so an appeal was filed. He wants to know if it was a better approach to file an appeal or to file a lawsuit. So it does really depend on the specific reason for denial. There are many cases where a lawsuit can have a lot of more benefit than filing an appeal. First of all, a lawsuit can get you a much faster result. We see results a lot of times within 60 days of filing a lawsuit versus an appeal. Once it gets to the AAO, it can take a minimum of 6 months to be processed. And then even if the AAO overturns the denial, they're going to send the case back to USCIS. They're going to take their sweet time to actually issue an approval. So it could take 6, 8, 10, 12 months for the appeal to process versus 60 days with litigation. So again, it does really depend on the reason for denial and the specifics of the case. If you want to have it looked into further, I would suggest contacting our litigation team. You can send them an email at litigation@rnlawgroup.com, or you can set up a consultation with any of our litigation team members. We have their information on rnlawgroup.com.
Sarvana from YouTube has this question. Does the Freedom of Information Act, FOIA, with USCIS, can that tell whether the I-140 was being revoked, withdrawn, or still active? Yes, the answer is clearly yes. And for those people who are listening to this one, if you don't have your I-140 approval, please, go ahead and file a Freedom of Information Act, because the future lawyers that you're going to contact on immigration would like to see the copy of the petition that's there. So please file it. It's free. It's online. FOIA USCIS. We do not recommend, to go through a lawyer. It's so simple. I mean, we do not. It's up to you, but we do not recommend to go through a lawyer. It's why go through the expense? It's simple. Once you file it, you get in 60 days. If you don't have an I-140 approval with you, please file a Freedom of Information. You'll get it.
Tushar from Facebook, his wife is planning to do a master's degree. It's a 100% online program, and he wants to know if she would be eligible for CPT, OPT, or STEM OPT based on that. Unfortunately, the answer is no. You have to have and be in F1 status in order to qualify for CPT, OPT, or STEM, and F1 status is not available for online programs.
Emily, they are issuing the F1 status. They are issuing the CPT. USCIS is issuing the OPT. USCIS is issuing the STEM extension. Now, in this particular case, it's a nonprofit though. So it's nonprofit and public. So they are issuing, it's online. What's your comment on that?
I don't think that's proper.
There are 100,000 people in there that are going. Are you telling all the people are improper?
Yeah, I mean, how many people were going to the University of Farmington or the University of Northern New Jersey or of Tri-Valley? University.
And Silicon Valley University got into trouble.
And they were all approved to go there.
They were all approved to go. They all got into trouble. We have been consistently saying that these day one CPT universities are not legal according to us. We have been telling it from past 2 years continuously. We know under what pressure that you are, why you are joining these universities, but please consider that it is completely illegal the way these universities are operating. Imagine this, the class starts, every 2 weeks the college starts. Really? That's how the universities are? Every 2 weeks. I went on there, every 2 weeks. You don't need any previous education qualification to get a doctorate degree, to join a doctorate degree. You don't need any examinations to be taken. Does the university start like that? Then you don't have to go to the university. Oh, really? And then guess what? You get a work permit. Does this all look like a fraud to you guys? It looks to me fraud. For the USCIS, it looks for a fraud. And recently we started seeing a lot of pushback from the US consulates outside the country for those people who are going to the university that does not conduct weekly physical classes, that the program starts anytime you want to. There is no requirement for you to join the university, no education requirement. And it's online. All these things are sounding, and there's a lot of pushback from the USCIS. They are noticing it. And there are 4 universities that already got into trouble. Farmington University, which actually was a fake university, University of Northern New Jersey. And then we have Silicon Valley University and Tri-Valley University. Both of the university authorities are in, if they're in jail for a period of time, I don't know how long they've been, but they've been in jail for conducting. So be careful, don't involve in these things. Don't fall into this trap, guys. It seems that there are a lot of questions that comes out. Yesterday, a news channel contacted me and said, why can't the USCIS go and take the permission to allow these people to issue the F1 visa? That's a good question. The journalist asked, why can't they do it? Because I feel that this administration is trying to trap a big number of people. They are not taking off the CIVIS authorization for these particularly 3 universities that are giving day one CPTs. And so you don't fall into it. There will be big news, and this administration wants to get there where they want to declare all these universities at one point of time. They want to trap you guys by going to these universities. That's the reason they are giving CPTs. OPTs have been issued by the immigration. STEM extensions are issued by the immigration. So they're trapping, don't fall into the trap.
Sai Krishna from YouTube wants to know what happens if my OPT extension ends by the time I get the result of an H-1B denial lawsuit. So while the lawsuit is pending, the lawsuit by itself does not provide any status or extension of your work authorization. So if your OPT expires while you're waiting for the result of the lawsuit, you have to stop working. And depending on the situation with the H-1B, if it's not been reopened, you may need to find another way to maintain your status. You have your 60-day grace period at the end of your F1 OPT. You could use that time. You could use that to re-enroll in a new program, file a change of status to some other type of visa that you might qualify for, possibly exit the U.S. As part of the lawsuit, there may be an option to do what's called a preliminary injunction, which would force or ask the court to force USCIS to keep you in status or to not remove you from the country or not enforce any immigration violations on you while you're waiting, but that's not normally included in the lawsuit. It's an extra filing, extra motion that has to be made. Can be a little bit expensive to get that done.
Vikram from YouTube is asking the question, are you seeing an increased RFEs and H4 EAD? What is the nature of these RFEs? No, we're not seeing increased RFEs and H4 EAD. If at all, when we see an RFEs, it's either because the USCIS says that, oh, we don't have the I-140 approval, and the client says that they included it, but they don't. And some of the RFEs are, the pictures are not proper or the pictures are not attached. That's all. We haven't seen any increase in the H4 EAD. Amit from Facebook has a question. His wife is a dependent on GCEAD. She's not the main applicant. Can she can she join an MS? A Master of Science? Absolutely, no problem. She's on GCEAD, which is on Adjustment of Status Pending EAD. She's a dependent. Absolutely, she can go to school. No problem with that.
Sudeep from YouTube has an H-1B visa stamp that's approved until 2021, but it has his previous employer's name and receipt number on it. He is planning to go for stamping, or planning to travel again. I assume he's got a new I-797 approval notice for a transfer to a new employer. He wants to know if he needs to go for stamping again. The answer is no. Once you have a valid H-1B visa stamp, even though it's got the old employer's name on it, you can still use that visa up until the time it expires in order to enter the U.S. with a new employer's approval notice. Just make sure to check the date, the end date that they give you before you walk away at the airport there, because a lot of times we see that they will give the end date of your I-94 to match the old visa stamp rather than the new I-797 approval notice. So you need to get that corrected before you walk away.
Emily, I need your attention on this YouTube question for Sarvani. She got laid off and she's leaving to her country. How long afterwards? She has some period of time left on the H-1B period out of the 6 years. How long afterwards can she come back on H-1B?
Forever. There's no limit on that.
Why is that there is a concept there that they can only come within 6 years after their first H-1B approval?
Yeah.
Or within the period of time the H-1B expires? Where does that rumor confusing Sarvani and a lot of other people though?
I think that it's based on the old regulatory language that said something about within 6 years, and they copied that language onto the form instructions before they changed the form instructions. So you'd have to check a box that said, I've been counted within the last 6 years. They took that within the last 6 years off, so that is not a requirement anymore.
Same answer to the Akanksha Gupta from Facebook is that he's asking, I am an H4 EAD, I'm eligible for the H1B, can I apply for H1B when they are going to take the H4 EAD off? If you are eligible for a H1B and you had a H1B before, you had a time period left or your I-140 is approved, yes, you can always apply from H4 to H1B without subject to cap. And one other thing, Akanksha, is that if you are an H4 EAD, you can even file the I-140. There are a lot of people that get confused that labor and I-140 can only be filed when they're an H1B. No, on H4 EAD also you can file. So a lot of people who are maxed out on the H1B, they move to the H4 EAD and they file for their I-140 and they resurrected their H1B. That can happen, and you can do that too.
Vignesh from Facebook wants to know, what's the time for a perm audit response? Generally just a couple of months. There don't seem to be taking any particularly long period of time, and that information is publicly available. You can look at the perm processing times through the iCert website. And note that when they list those processing times for the audit response, they go by the original filing date, not the date that you got the audit or not the date that the audit was responded to. So they will give you the exact month and year of cases that they're working on audits for right now.
Naveen has this interesting and very good question though. When we sue the USCIS, would we get the expenses refunded or reimbursed? Here is the issue. I want to go back to the early part of this video though, where Emily has said that she won the H-1B, they got the H-1B approval, but we didn't win the case. Now here is how it works out. The H-1B got denied, we sued the USCIS, the USCIS reopened the case and approved the H-1B. Now, there is nothing there for us to fight in the court. We withdraw the complaint that we made to the court, making immigration win the case. So here, we are not winning the case in the federal court litigation. We are just getting the H-1B approval. And yes, if you want the expenses refunded or reimbursed, there's a different way of going. We are not good in that thing. We just want our H-1B approval, and your money will not be refunded. And we are actually losing the case. Technically speaking, we are withdrawing the complaint. We are winning your H1B, but in front of the judge, we are not actually winning the case. Is that right, Emily?
Yeah, absolutely.
And most of our H4 EAD litigation also, when we go and file the case, they have 60 days to respond. They just approve all the cases, and then we withdraw the complaint. Or we have a compromise where certain sort. So normally they don't let us win. They just let our H1Bs and H4s to be approved, and we let them win in the court.
Kushal from Facebook is going to be taking up a new role in his organization and wants to know if he needs to file an amendment. He got his H-1B picked this year. So it really depends on the difference in the new role. If it is considered a material change in job duties, then yes, an amendment is required. If it's just a simple change in job title where the duties remain the same, then no, an amendment is not required. So it really depends on the specific circumstances.
Karthik has this question: is there a stricter limit on H1B decision filing the lawsuit? That's a good question, Karthik. Unlike the appeal or motion to reconsider, where that 30 days is that 30 days is not applicable. Yeah, can you file after 4 years? No, because you only asked for 3 years. Can you file after 3 months court litigation? Yes, you can. You don't have any issues filing in 60 days, 90 days, 100 days, 120 days. But yeah, if it's going to be more than 1 year, you will probably have to speak with a lawyer before we can say that it's within 1 year. We don't see any problem, and there is no statutory limit on that.
Jagadish from Facebook, his wife already has her H4 approval but needs to apply for her H4 EAD extension, and he wants to know how long is it taking to get just the H4 EAD extension approved. I think even those are still taking 4 to 6 months to get approved. It's better than filing it with the I-539, but still a delay. And if the current EAD expires while you're waiting for the new one to be approved, you have to stop working until you get the new one approved.
Carlos got his green card. He was an H1B. Does he need to carry the H1B when he is going outside the country and coming back? Absolutely not. You don't need H1B. That's kick it like a football. It's gone. Just use the green card for you to go outside the country and come in. Of course, you need to have your passport along with it at all times.
Vijaya wants to know about a nunc-pro-tunc extension. Can you tell us a little bit about what nunc-pro-tunc is before I get into the details of that case?
When a person's I-94 expires, for example, if you have a H-1B approved until September of 2019, you filed an extension of the H-1B and you got the denial in November, and that means that your I-94 expired, you don't have any petition pending. You can request the USCIS for excusing for not having the current I-94. That's called non-pro-tunc. That means that please excuse me for being out of status, but you have to meet certain conditions for that. The conditions are that that it was beyond your control that you went out of status, and what's the other requirement?
It was due to extraordinary
circumstances under which why you are. Although it says that you cannot work, but in this H1B case where when your extension is pending, that's not applicable. So if these two things are that it was beyond your control and it's extraordinary,
extraordinary circumstances beyond your control, beyond your company's control. So that's where the difficulty is. If it's filed after an H-1B denial, was that denial an extraordinary circumstance that was beyond your control and beyond the company's control? Sometimes we win those, sometimes we lose them. I'd say it's about a 50-50 chance.
Especially if it's a short-term approval where they have given an approval where they approved your H-1B in November, but they only gave it to you until October of 2019. We have seen a lot of success with the USCIS. But at the same time, when it's been transferred or when an extension has been denied because of the specialty occupation and you are filing a non-pro-tunc argument, we're noticing that they're not issuing the H-1B approval with the I-94, but they're still issuing the H-1B without the I-94, though denying the I-94. So it may be worth for you to consider that. But I will tell you one thing, that under all circumstances, please, when you file a non-proton, file only under premium processing, because you are already counting the unlawful, you may be counting the unlawful presence. If you file under the normal processing and your change of status, when your non-proton case get denied 8 months later on, you may have a bar coming back into the United States. So I would strongly suggest that if you were to use a non-proton, only use for in premium processing. Don't use under normal processing.
All right.
One question comes from YouTube. Prasada is asking, once I get the green card, how soon can I change the job? You can do it next day. There were some issues before the AC-21 law came into picture, Mr. Prasad, but right now, under the AC-21 the law, yeah, you can move the job next day. I don't see any problem in it.
Ashwini from YouTube says that the lottery was selected, her H-1B was selected in the lottery all the way back in April 2018, received an RFE in March 2019, and it's still pending. Any idea what is taking this long? Please upgrade to premium processing. There's no reason for you to wait this long.
Stop listening to this video and just go and get the premium processing done. Absolutely no reason. Emily, there are some people who believe that, oh, if you do in premium processing, you get a chance of higher RFE or denial. Is that true?
It's not true at all. I mean, we file a lot in premium processing. Almost everything I personally file, I file it in premium processing or highly recommend it to my employers that I represent, because there's just no reason to, I mean, April 2018, that's a year and a half. You're sitting around wondering, questioning, wanting to be able to work. There's just no reason for that when you have a simple solution to that. Premium processing does not cause RFEs. It does not cause denials. There's not a higher chance of denials because those officers are more scrutinizing. All of that is just rumors. Definitely, you know, I think many times some employers don't want to upgrade to premium processing because they want you to be able to keep working. If you do upgrade to premium and maybe it's a weak case and it does get denied, you know, if it's an extension or a transfer, then you've got to stop working. So it's in the employer's best interest to keep it pending as long as possible. But that might not be in your best interest. You need to get it over with and upgrade.
Sudeep has this question, is I-797 is valid, his H-1B stamping is expired, can he go to Mexico on a cruise and come back? Going to Mexico is not going to be an issue for you to go and come back if you are going for a cruise and you're staying less than 30 days. But if you were to go to any other thing other than Mexico, for example, these Caribbean islands, no, you cannot. Only there are certain limitations with it. Don't go. If it's Mexico, I'm fine with it. I didn't see any problem, but if you're going to Caribbean islands, you need to check with a lawyer before you go there.
Deepankar from YouTube is planning to go for H-1B stamping soon. His background is that he has a PhD in organic chemistry working in radiology and wants to know what are the chances of getting a 221G. So I assume you're talking about this needing to get a security advisory opinion because of your education background. So there is a kind of a technology alert list out there that consular officers, if they see someone that has a background or education in a sensitive technology, before they will issue the visa, they have to get a security advisory opinion done first, and that can take a couple of weeks. So that is a kind of an administrative processing or 221G. They don't publicize the list of what education backgrounds specifically cause a 221G or require that security alert list. I can't say off the top of my head that organic chemistry specifically does, but I know people that have done biochemistry have been subject to that, so definitely be prepared for it. Understand that it can take an extra 6 to 8 weeks for you to get your visa stamped because of it.
Can I travel to India to the H-1B stamping while the amendment for location change is pending? No, you can't, because it's not approved there yet. So going to the consulate saying that give me the approval while USCIS is still pending, no. Try to do the premium processing, get that approval, and then go. That will be the best chance that you have.
Sharmila from Facebook is on H4 and wants to apply for an F1 and her school is telling her she doesn't have to pay the biometric fee.
Oh, really?
That is incorrect. So if you're filing for a change of status from H4 to F1, On the I-539 form, the biometric $80 fee is mandatory.
If you're filing for I-539, whatever visa, there are many different visas that I-539 is used. You have to pay the biometric fees. Even if you have a kid who is 4 years old, you still need to pay the biometric fees, unfortunately. That's there.
Venu from YouTube has a question about an agreement that his employer is making him sign. So in order to file his H-1B extension, the employer wants him to sign an agreement that says if he leaves the company before the 3-year H-1B extension period, he has to pay a fine, and he wants to know if that's legal. There are certain requirements that an employer has to meet. They cannot make you pay back the cost of getting your H-1B, so they can't make you repay attorney's fees or filing fees for the H-1B. They call it a fine. They can request liquidated damages. There can be a liquidated damages penalty, which is different from a fine, but if there is a liquidated damages penalty, they have to put that information in their public access file. They have to be prepared to specify how they calculated that amount of the fine or the liquidated damages. And it can actually be found to be a violation of the LCA regulations. So I think that you may want to have someone, an attorney, take a look at that provision before you sign anything, and may not want to continue with that employer.
A lot of people are asking is the rules of the H4 EAD. At this point of time, we have updated many times before. At this point of time, it's just a proposed regulation. There is not even it's just proposed regulation. We're expecting that it may take a long time for them, especially REDDY NEUMANN PC is also ready to sue them. They know that they're going to get sued on that. So they have to be very careful. They are definitely considering removal of the H4 EAD. But to become effective by March 2020, I think so it's going to be very tough to become effective by March 2020. But we'll keep you updated when the proposal comes in. We will give you drafts of what you need to write a letter to contest these regulations. So please keep tuned at REDDY NEUMANN PC at different places, YouTube, Facebook, and also at Immigration Blog at Immigration Girl, which Emily manages it.
Ashatote from YouTube has a very technical question about H-1B. He wants to know if an H-1B transfer is really just a new H-1B that is CAP exempt. Kind of. So the proper term for an H-1B transfer is actually an H-1B change of employer, which is different than a new H-1B. And the reason for that difference is how the form is worded. There's actually different categories to check. There's one for new employment, there's one for change of employer, there's one for amend the stay, there's one for continuation, which would be an extension. So there is a difference between new H-1B and change of employer in terms of how you're filling out the actual I-129 form. But you know, practically, yeah, it's basically just another H-1B that's not subject to the cap because you've already been counted.
Emily, finally, the regulations are out with regards to the registration process of the H-1B. So can I register right now? Can you give the details? This question comes from Chaitra from YouTube.
Yeah, great question. We know it's coming, but we don't know when and we don't know what. So unfortunately, still a lot of unanswered questions. What we do know is that when we can register, we will have a 2-week window, and that they have to announce that 2-week window at least 30 days in advance. So that tells me by mid-February at the latest, we should get an announcement, because that will put the 30 days the mid-March, so that we would have the last 2 weeks in March to potentially register. So you can't register yet. The system is not operational.
Krishna from YouTube has this question. His base salary has been increased. Will he has any trouble in the visa interview? I have to say that I have not seen anybody getting trouble because they're getting more than the LCA wage, but he may have to, if the wage has been increased significantly, there are other problems you might face. But have you seen any consulate problem, Emily?
No, I think if it's just a promotion, a typical salary adjustment that happens as you gain more experience, that's pretty common. But like you said, if it's such a big, significant change that would make the consular officer question if you're still doing the same job, then that could raise issues at the stamping. Naveen from YouTube wants to know if a QA analyst is a specialty occupation. Unfortunately, there's no way to answer that question because what you really have to look at is the duties of the position. So USCIS does not rely on title alone. They do look at what occupation category that the position falls under based on the job duties, and you list that on the LCA. So depending on which occupation code was selected for the LCA, I think there are plenty of QA analyst positions that don't qualify as specialty occupation, and there are some that probably do. But it's all going to be based on what occupation code, what the wage level is, and what the actual job duties are to determine whether it's a specialty occupation.
RK from YouTube has a very interesting and technical question. The automatic visa revalidation, if his I-140 is approved, will that cause any problem in his entering back into the country? Assuming that you are trying to enter back into the country on H1 and H4 and you're otherwise qualified for automatic visa revalidation, that means that you're going to Canada or Mexico coming back within 30 days and your I-94 is still valid. If you're coming on H1 and H4, your immigration intent will never be a problem. Not only in this automatic revalidation, when you apply for the visa stamping, when you're trying to enter into the country, it's not a problem. Because H1, H4, L1, L2s are considered to be a dual intent visas. Now, if you have an I-140 approval and you are trying to come back on F1 automatic revalidation, that may be a problem for you, RK. But if you're trying to come on L2, L1, H1 and H4, I don't see any problem whatsoever at all.
All right. Nitin from YouTube, currently working on L2 EAD, and that's expiring this coming January. Already applied for the extension back in August, and nothing is happening. Tried to do expedite request. USCIS won't do it. What can be done? The only thing that we have found that works in that situation is a lawsuit. We are filing lawsuits on behalf of L2 EAD holders that have a pending extension. It's exactly the same case for the H4 EAD. We combine them all together to keep the costs down for you. We're going to be filing our next one, not this week, but
December 6th.
December 6th is the next one we are going to be filing. So if you want to, you can get in contact with our litigation team by emailing litigation@rnlawgroup.com, or you can send an email to info@rnlawgroup.com to get the information about the cost and the process for that. Once the lawsuit is filed, it can take up to 60 days to see the L2 and the EAD get approved.
Do you have a premium processing for the L1B extension from Anand Raj from YouTube? The answer is yes, you do have a premium processing for L1B extension. It's 6 o'clock, Emily. Thank you guys for coming in.
Thanks for joining. If we weren't able to get to your question today, you can always join our daily conference call. The information is at rnlawgroup.com. You can get the schedule there and the dial-in information. If you'd like more detailed information about your specific situation, you can set up a consultation with us or any of our 15 attorneys within our office. We'd be happy to help you, guide you on your situation. Remember to subscribe to our newsletter at rnlawgroup.com. You can also subscribe to immigrationgirl.com, where I give you the latest updates and practical information all about employment-based immigration. Thanks for joining today.
Thank you guys for tuning in.
And happy Thanksgiving.